Well, what a week! What a fortnight it's been in company law. This is 2008, September 2008. We've seen some really interesting things happen with the trading into shares and stock markets. Probably fairly important. Okay. So what have we done in the last lecture? Well, we looked at the issuing of shares and debentures. They're called securities, and how you can do an initial offering. That's where the shares haven't been issued before, and then they can do secondary trading, where the shares are traded on a market such as the Australian Securities Exchange, and that's and there are some practices which are illegal, things like insider trading, market rigging, misleading information, putting that out. Yes, they're very serious offences, so you need to know about that. And the idea of disclosure, yes, the idea that you have to let people know what's going on. That's right. What's up, Angel of Learning? A robo-lawyer and pencil dog have been saying silly things. What have they been saying? Oh, they've been talking about naked short selling. Yes. What's that, Robo? You put some clothes on because you don't want to be seen to be naked. Okay, you've got this garment on. We'll call it a garment. Yes. So, yeah. Well, naked short selling has got nothing to do about people selling their shorts so they're naked or anything like that. It's a type of trading on the stock exchange where people sell shares they don't own. They enter into a contract to sell shares which they don't own at a particular price, and they hope that when they go to buy those shares to pass on to the person they sold them to, that the price has gone down, and if they can do that, they can make money. Yeah. Yes, so that, well, what's the difference between naked short selling and covered short selling? Oh dear. Well, as I understand it, and could be wrong, covered short selling is where someone actually borrows shares so that they do have shares there in case they can't get them in time, so that's covered. But all short selling has been banned in Australia for the moment, so that's something new. Yes. Now, the other thing we looked at was the idea of the takeovers. Now, the idea is when someone wants to take over a company, they don't necessarily have to get 50% or more of the shares. The regulator recognises that with large public companies we could have lots of a much smaller shareholding, like about 20% or something like that. And if people have a holding of 20% or more and they increase it, they have to let the regulator know. What's that, robo-lawyer? You think, why can't we get around it? Like, if we want to do a takeover, you'd buy some shares, Angel of Learning would buy some shares, Pencil Dog would buy some shares, I'd buy some shares, and we could put them all together and get control of a company that way. Well, regulators thought about that too. They've beaten us there because we'd be all called associates in that case, and that's they'd want to count all our shareholdings together because they don't count shareholdings, they count something called a relevant interest in the shares. Are there different ways you can do takeovers? Yes, there's a couple of ways set out in the textbook. One's called an on-market bid, one's called an off-market bid, and there are some differences between them. And it's probably that the important thing about following the procedure prescribed in the law is you have to give the shareholders full information. Yes, always on about it in company law, aren't they? Yes. What? Disclosure. What's that, Pencil Dog? Why do you have to let everyone know what you're doing? Well, you don't have to all the time. In fact, there are exceptions to that continuous disclosure requirement, especially if it's confidential business information. But the idea is so that people out there have faith in the Australian share market. They know that if they invest there, there's not other backroom deals going on where they're not part of and they don't miss out. So that's the idea of that. Okay, so we write now about the changes to the laws that have just happened. That's very interesting. That's all. What you want to know? Is Australia in the same position as the United States? Goodness, Robo-Lawyer, you have some strange ideas. What have you been doing? Reading the Australian or the Financial Review or something? Look, now, I think probably the difference there is that the mortgage laws in Australia are somewhat different to the United States in that if a mortgagee defaults and the mortgagor defaults rather, that's a mortgagor, the mortgagee sells the property, and if there's not enough money realised to cover the amount owing, the mortgagee can then sue the defaulting mortgagor personally to recover the balance owing. Well, in a lot of cases in the United States, that's not the situation. Once there's been a foreclosure on the property, the mortgagor is no longer required to make up any shortfall, and that's probably a significant difference, which a lot of people don't understand. Right? We're going to come back later on and talk about the exam. I think we will. What do you think? And we say goodbye for this week. We've got a new look this week. We've got a new camera angle. We're investing in a tripod as opposed to books and coat stands and things like that. So okay, well, we'll say goodbye, everybody. Goodbye, Robo-Lawyer. Goodbye, Pencil Dog. There's Angel of Learning. Come out there, Angel of Learning. Some people say they can't see Angel of Learning all that clearly. You're dwarfed by the others. Okay, that's why I've put you on a blue background. Okay, well, we'll leave it there for this week. Oh dear. Okay, about takeovers, securities, secondary trading, initial offerings, all sorts of things, yeah. Oh, floating. Floating. No, we won't go into that. Floating is when the shares are offered for first time. Okay, but you don't have to know a lot about that. There are whole courses on it. Okay, we'll leave that.